Welcome to the Workology podcast, where we discuss the science and art of the workplace, gain powerful insights, resources, and perspectives on the industries of human resources and recruiting. Join your host, Jessica Miller-Merrill, chief blogger of bloggingforjobs.com, for an in-depth and no-holds-barred look into the future of our most powerful business asset, the employee. And now, welcome your host, Jessica, with this podcast episode of Workology.
Welcome to the Workology podcast, and thank you for making us part of your week. Our guest today is Casey Sipe. Casey is a management-side labor and employment attorney with Caldwell & Kearns in Harrisburg, Pennsylvania. He writes about labor and employment on his blog, The Employer's Lawyer, and also is a contributing writer over on Blogging for Jobs. Casey, welcome to the Workology podcast. Thank you for joining us.
Thanks for having me. I always have a good time joining you on the podcast.
So we're talking about an interesting topic today, and before we decided to air or to talk about the subject, I had a journalist from major publication contact me asking questions about this. And I thought, wow, I haven't read a lot of information about these changes. And when I'm talking about these changes, I'm talking about EEOC's proposed changes on the guidance of GINA, or the Genetic Information Non-Discrimination Act of 2008, and another set of proposed changes regarding how employees monitor, manage, and recognize company wellness programs. So you might not have heard a lot about this. I feel like all the hubbub about the FLSA, which we've done a couple podcasts on, and Casey's been our subject matter expert to talk about that, might have overshadowed the GINA and the wellness program sort of new directives that are coming down from the EEOC.
Absolutely. I think you put it perfectly. The focus really has been on the FLSA and the GINA and ADA proposed rulemakings from the EEOC have kind of snuck in under the radar. This kind of hit my radar about a year ago, actually, because there was a case that Kate Bischoff actually put in front of me between the EEOC and Honeywell over Honeywell's requirement that employees provide certain information as part of the employee wellness program. And that, I believe, is a lot of what has kickstarted this proposed rulemaking.
Let's first start with GINA. Can you give us a rundown of what GINA is for those of us who might not be familiar?
Sure, and I expect a lot of people are not familiar. It's the federal employment law that probably gets the least amount of attention. So as you said, it's the Genetic Information Non-Discrimination Act, and it basically prohibits discrimination on the basis of genetic history, which kind of sounds like an odd thing to focus on, but what they're really trying to do is prevent employees from being discriminated against based on their family health history, and to protect employees from having to disclose certain information to their employers. It doesn't allow an employer to discriminate, harass, or retaliate against you based on something in your health history. So, for example, if your employer were to somehow find out that both of your parents had diabetes and that you are, predisposed to diabetes or something like that, they can't take any action against you on that basis.
Let's talk about the proposed changes by the EEOC. So we've gotten the rundown of what GINA is, at least a quick summary. Can you talk about what the EEOC is proposing?
Sure. So the proposed rulemaking is pretty much directly related to these employer wellness plans that are becoming more and more popular. And this rulemaking actually addresses specifically the employer's incentives for an employee's spouse to provide information about his or her current or past health status as part of the wellness plan. So under the current rules, it certainly could be read to prohibit an employer from providing an incentive for the spouse providing this information. So they're trying to propose a framework that will allow an employer to provide these incentives. So basically what it's saying is that an employer can provide a limited incentive, either in the form of a reward or a penalty, to an employee whose spouse is covered under the employment plan or the employee's health plan, receives either health or genetic services offered by the employer, usually included as part of the wellness program, and then provides information about his or her current or past health status. And this information can either be part of an assessment by filling out a questionnaire, or even by undergoing a medical examination like a blood test, or having your blood pressure checked, or things like that. It also limits the amount of the incentive. It cannot be more than 30% of the total cost of the plan in which the employee and any of their dependents are enrolled. Now, the incentive can actually be in the form of money, so either a reduction of the premiums or a bonus or something like that. It can also be in kind, which means you can give time off, you can give prizes, or really any other item of value. You just have to be careful about, if you're doing the in-kind incentives, that you're not going overboard. If your limit is, say, $4,000 in incentives, you don't want to be giving $4,500, items, or items totaling $4,500. And then it actually further clarifies that a little bit by saying that the incentive that can be offered to the employee alone can't exceed 30% of the total cost for the self-only coverage. So to put that another way, if self-only coverage is a cost of $6,000, the max portion of the incentive that can be offered for the employee's participation is $1,800, which is 30% of the $6,000. The rest of any incentive can come if the spouse participates in the wellness plan as well. So, and then finally, it says that any health or genetic services that are offered have to be reasonably designed to promote health or prevent disease. So that basically just means there needs to be a reasonable chance of improving the health of the employee or preventing a disease in any participants. So they just can't be overly burdensome or anything like that. I mean, honestly, I have a hard time imagining that anybody is going to have a health plan, a wellness plan that is providing a service that does not have a reasonable chance of improving the health of the employee. Most of them tend to be smoking cessation, weight loss type programs, or just general guidance based on your health profile. If you have high cholesterol, they'll offer suggestions on how to lower it and that sort of thing.
I think all this is kind of interesting because as employers are trying to look to lower healthcare costs, right? They're getting more active in employee wellness and getting those spouses and other family members who are part of a family healthcare plan. It just gets a little crazy because that information that they're providing or they're receiving, they can't use that for employment purposes. And then you tack on the compensation incentives, like for you to complete the information. I think it's a good guideline, and I understand why the EEOC is wanting to put down more information on this.
Yeah, absolutely. I mean, it's always one of those things where the more information you have, the more likely it is that the information will be misused.
It's really challenging for employers, I think, with the subject of medical information. So we have GINA, and then I've been doing a lot of research and work with HIPAA. And as I said, employers need to be very careful with the sharing of, storage, and maintaining of employee and spouse health data. Do you have any advice for HR professionals out there?
Sure. The easiest way to limit the risk is to limit the amount of the data that you actually keep on hand. Whether that means going through a third party to administer, or, to collect and hold the data. That might actually be a way to go, depending on the size of your business. The other thing is to make sure you're not asking for more information than you need. Not only because that puts the more data you have, the more the data is at risk, but it also, if you're asking for things you're not allowed to, it could violate the Americans with Disabilities Act. Of course, that's a whole nother topic, but it's pretty unreasonable nowadays to expect that you're not going to be acquiring some data, especially if you have a wellness plan. So really what you need to do is limit access to the data. So if you are keeping it on a computer, make sure that it's password protected and that only the people that absolutely need access to it have access to it. Or if you're more low tech, making sure it's in a locked room, locked file cabinet, that sort of thing, with only certain people having access to it. Additionally, I think you want to have policies in place that address the access and use of health data by employees. And I mean, I would, advise my clients that accessing another employee's health data without permission or good cause should be a terminable offense. It's a pretty serious invasion of privacy. It exposes the employer to a lot of liability. So, a strong response from the employer is certainly warranted.
Well, let's take a little bit of a reset here. This is Jessica Miller-Merrill, and you're listening to the Workology podcast, powered by Blogging for Jobs. Today's topic is understanding the 2016 EEOC changes for GINA and wellness programs with Casey Sipe. You can also follow Casey on Twitter at CLS Employer Law. Well, let's talk a little bit more about the EEOC. They have a separate resource on just wellness programs. And I'll be putting a list of resources in our podcast section for this particular episode. So you can just go to bloggingforjobs.com and go over to the right-hand sidebar and search for GINA podcast or wellness programs podcast. And I'll get you to the EEOC resources and additional information. We'll probably put the Honeywell case, just some information in there as we're referencing here today. Let's go back to wellness programs. And so I'm pulling this from the EEOC's website on the official definition of their wellness program. And it refers to programs and activities typically offered through employer-provided health plans as a means to help employees improve health and reduce healthcare costs. Some wellness programs ask employees to engage in healthier behavior, as Casey was mentioning, becoming more active, not smoking, eating better, while other programs obtain medical information from employees by asking them to complete a health risk assessment, or an HRA, or undergo biometric screening for risk factors such as high blood pressure or cholesterol. Why is there such an important distinction for a company to have a wellness program that needs to be voluntary, Casey?
Well, under both GINA and the ADA, employers are limited in accessing medical information of their employees. So in most, if not all of these wellness programs, the employee is going to be required to submit a certain amount of medical information. So there needs to be an option by the employee to decline to provide that information just for the sake of privacy. Additionally, the EEOC is taking steps to make sure that employees don't feel coerced into joining these wellness programs. Some people just don't want to participate because they don't want to do anything extra. Maybe they're just happy with their life and they don't think it needs to change. Others feel that, like I said, it violates their privacy. So whatever the reason for not wanting to join, the EEOC wants to make sure it's not overly burdensome for them to decline. That's why the proposed rulemaking limits the incentive to 30% of the plan cost, so that non-participating employees aren't spending thousands and thousands of dollars extra and feel like they have to join the wellness program out of financial necessity.
Well, let's talk a little bit more about the ADA or the Americans with Disabilities Act. Can you kind of walk us through how this fits into wellness programs a little bit more?
Sure. The ADA does limit circumstances in which an employer can ask employees about their health or require them to undergo medical exams. Generally, those exams have to be voluntary and they have to be a part of an employee health program. The reason behind the limitation is because, again, it's one of those situations of the more you know, the more likely it is that information could be misused. So if employers are permitted to just willy-nilly require medical exams for every employee, they might find out that somebody has a history of high blood pressure or that they have, gout that might cause them to miss, time off work and things like that. So it's an attempt to prevent discrimination. But the proposed rule makes it clear that wellness programs are permitted under the ADA, but they can't be used to discriminate on disability. So, like I said, if your health exam shows that you have heart disease, they can't increase your insurance premiums, and they certainly can't decline to provide you the incentives.
So when I was talking to this reporter and we were talking about the changes, one of the things that I was thinking about is with the Affordable Care Act, or the ACA, and a number of employees seeking outside insurance through the state exchanges, this might not be as important as maybe the EEOC is thinking. What are your thoughts on this?
More and more people are going out to get insurance through the Affordable Care Act and going to the healthcare exchanges. There's still a very significant number of employees that are on employer-sponsored plans, and I really don't see that changing, particularly with the large and medium-sized employers being required to provide insurance to their employees. Now, of course, there's a question of whether it's more financially beneficial for the employee to go through the employer or the Affordable Care Act healthcare exchange. That's an entirely different subject, but I still think that employer-sponsored plans are going to be the majority of insurance coverage going forward in the near future. So while the Affordable Care Act has somewhat diminished the role of employer-sponsored plans, I don't think they're going anywhere soon. And I also think that given the ACA's impact, that wellness plans are going to become a larger and larger part of the equation in terms of keeping healthcare costs under control.
Good point. I'm just, also thinking about this year being a presidential election year, and so ACA could change once we have a new president as well.
Absolutely, and it's pretty much been under constant challenge, whether in Congress or in the Supreme Court. So nobody really knows how things are going to shake out over the next couple of years with regard to the ACA. So I think that the EEOC is probably just moving forward under the assumption that employer-sponsored plans are still going to be the majority of health coverage in the country.
Where can people go to learn more about you, Casey?
Well, you can find me on LinkedIn, of course, Twitter, as you said, at CLS Employer Law. You can go to my blog, The Employer's Lawyer, which is employers-lawyer.com. And if you think that this whole law thing is boring, but you like clothes, I also have an Instagram account at The Amateur Professional.
What's on your Instagram account? Because I love this.
Well, so I don't like boring office clothes, so I post pictures of what I wear to work every day. Tends to be a lot of fun patterns and sport coats and pocket squares and all that kind of stuff. So it's just a little something that I've started doing on the side.
I love it. I love it. If you saw what I wear to work every day, it wouldn't be as exciting as what you wear to work.
Yeah, well, it's become something it's fun to do in the mornings. Usually at night. I need to pick out my clothes the night before now. I'm a little kid because I got to make sure everything matches and it's cool looking and everything.
Well, thank you for joining us, Casey. I appreciate it. And I thank everyone for listening to the Workology podcast, where we discuss the science and art of the workplace, HR, and recruitment. This is Jessica Miller-Merrill. Until next time, you can visit Blogging for Jobs to listen to all our previous Workology podcast episodes.
Production services for the Workology podcast with Jessica Miller-Merrill provided by Total Picture.